Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we are continuing our video series designed to inform the public, so please subscribe to our channel. What do you do once you receive a summons and complaint for divorce? This is how a case starts out. Somebody files a complaint, there's a summons issued, and then they're served upon an individual. What are you supposed to do with them? All of a sudden, you may not have even known that you were getting divorced. Now you got a bunch of legal papers. A bailiff hands them to you. Where do we go from here? Well, it's important to look at them, read them. I wouldn't spend too much time understanding them. They're going to have a lot of legalese that it's just probably going to intimidate you rather than enlighten you. But it is important to look at them anyway just to see whether or not there are any quickly approaching dates that have to be met. Are things happening, and in the documentation that you got, are there quickly approaching deadlines? This will tell you several things, not least among which is how soon do you have to contact a lawyer. If the summons and complaint, when you're served locally, you're going to have 21 days. That's all you're going to have. But depending on emergency circumstances, sometimes there are time limitations, things that come up, the obligations that have to be met sooner, and you need to make sure that you meet the timeline, because failure to meet those timelines could compromise your rights, could limit your ability to participate in the litigation in the way that you want to. So therefore, number one, let's see if we got any timelines, we got any time crunches. Very important to document exactly when you were served. And then, of course, what you've got to do is you've got to consult an experienced attorney. You got to say, look, I got a bunch of papers, not 100% sure what they mean, but they say something about a hearing that's coming up on Tuesday. What do I do about that? And the attorney's going to say, what you do? You fax those, you screenshot them, you somehow scan them and email them to me. We got to see them. And what will happen is, and this is protocol in our firm too, we'll get those papers, and then we will typically go over with the client, what does it mean? What are those papers all about? And as a result of that, what do you need to do? Sometimes the client may not need to do anything, but the attorneys have to do something immediately. Sometimes there are proceedings that are more attorney-based, less client-based. Sometimes the other way around. For example, in Oakland County, they conduct, when there's a divorce for children, EIC meetings, early intervention conferences. Now, those are really for attorney and client, but when they do those in person, and even on Zoom, after a brief introduction, the attorneys are excused. And then there's an hour spent educating the client on certain things, including the workings of the friend of the court and other things that the court tells clients about resources that are available to them. So that's a perfect example of something that has to be, that will come up, that has to be done, that has a date on it, and failure to go to those things carries sanctions with it. So you've got to watch for these kinds of things. I would say the most important thing, if I had to sum it up, once you get legal papers in your hand, and it's something you care about, like a divorce, like your children, like your job, like your home, at that point, you've got to reach out to a lawyer, tell them you got them, share the papers with the lawyer so the two of you can devise a strategy going forward. If you have any questions about your case, reach out. We'll be glad to help you out.